while all the participants get connected. The event is recorded. Interpretation is available in English and Portuguese. You can access the interpretation by clicking in the bottom of your screen and choose the language of your preference between English and Portuguese. You will be able to ask questions through the Q&A feature. We will be able to ask some of these questions to be answered live by our panelists or in written. Let me give a couple of minutes more for the participants to get connected before we get started. Good afternoon, everyone, and very warm welcome to this webinar. Today, we will explore the human rights and environmental impacts of the iron and steel industry in the Carajás Corridor and the responsibilities of the companies involved. Before we start, let me repeat again a few technical details for those who just arrived. This event is recorded. Interpretation is available in English and Portuguese. You can accede to interpretation by clicking on the button at the bottom of your screen. To interact with the panelists, you will be able to ask questions through the Q&A feature. We'll be able to respond to some of these questions in live or in written. I'm really honored today to officially open this webinar. A webinar that is the occasion for us to launch our latest FIDH report entitled Heavy Metal: From Abuse-Ridden Mines to Global Consumer Goods, the Journey of Brazilian Iron. This report, which you see on the screen and you will be able to read through the link that we will share in the chat, is the work of a long-term collaboration with Justiça nos Trilhos and Reporter Brasil that we started in 2010, where we first documented and alerted about the human rights abuses linked to the iron and steel industry, particularly in the community of Piquia de Baixo in Maranhão, Brazil. But this community is only one of the multiple communities along the Carajás Corridor that are negatively affected by the Carajás mining project. The iron and steel from the Carajás Corridor is tainted with human rights and environmental abuses, including violations of the right to health, adequate housing, land, and healthy environment, just to name a few. Our report, Heavy Metal, revealed the long journey of this metal charged with violations through a complex supply chain that involves steel companies around the world. The iron made in Brazil travels to global markets across the world to be transformed and end up in many of our consumer goods, from particularly the automotive, the appliance, and the infrastructure industry. This report focuses on identifying some of the main companies that are along this long and complex supply chain and analyze their links to the violations occurring on the ground. Its objective is to alert the buyers and other companies in the value chain of the human rights risks and adverse impacts that are taking place in the Carajás Corridor, and also to prompt them to examine and act upon their own human rights due diligence obligations and assess the extent to which their human rights due diligence practice are adequately addressing these human rights impacts. So this webinar is really the opportunity to present the findings of this report and connect it to a very interesting and rapidly evolving policy and regulatory context. We have two main events that have occurred recently. First, a couple of weeks ago, the announcement of the opening of accession discussions in 6 countries, including Brazil. And secondly, just yesterday, fresh out of the oven, the European Union proposal for Sustainable Corporate Due Diligence Directive. These proposals, which we will be able to examine more in detail through the webinar, introduces new rules on how sustainability should be incorporated into long-term business strategies. From this perspective, and departing from the specific case of the iron supply chain from Brazil, we will explore the opportunities that these recent developments present. We will first hear from Larissa Santos and Marcel Gomez that will describe the problem that has been identified in the report, the complexity of the supply chain, and some of the recommendations that are formulated. Later on, in the second half of the webinar, we will have Germán Samara, Silvia Oregon, and Julia Neiva, who will discuss what are some of the solutions or responses that we can give to these human rights and environmental abuses. From a corporate due diligence perspective and a policy and legal approach, what are the opportunities that are presented today? So with this, as you get comfortable and all the participants finish arriving, I want to introduce our first panelist, Larissa Santos. Larissa is policy coordinator at Justiça nos Trilhos, a Brazilian organization that for many years have fought for the defense of human rights of communities along the Carajás Corridor. And Larissa, let me welcome you and ask you, what are the human rights and environmental impacts of the iron and steel industry of the Carajás Corridor? And what is the regulatory context that has allowed this violation to persist for so many years and decades?
Obrigada, Maria Isabel.
Thank you, Maria Isabel. Good morning. Good morning, everyone who's been with us and who's here at this webinar today. Welcome to all the guests and everyone here who's here as a panelist. As Maria Isabel said, I represent Justiça nos Trilhos, and thank you so much for the opportunity to be here today to talk to you. I'm calling in from the Amazon, and it's very difficult to explain the context in this report. The Brazilian Amazon is affected by the Carajás project, which is the largest valley mining project in Brazil and in the world. This project started in 1980, and the objective was to ensure exploitation and transportation from mining and ore in the southeast of the Pará state, which is in the northern part of Brazil, and to get this and export it out of Brazil. This includes an 892-kilometer railway that connects the mines in the southeast of Pará state with the port in Madeira, which is located in the capital of Maranhão state. And in the report today, we see this context of the Carajás project through the experience of the Piquiá community. This Piquiá de Baixo suffers the consequences of mining and exploitation and the steel and iron industries. It's a very symbolic community for this report, since it's located right along the Carajás Railway, which is where all of the iron is exported. When this ore reaches Piquiá, part of it remains there so that it's processed and transformed, and it becomes steel. And this processing takes place in the plants that are located right next to PQA. So this leads to lots of negative problems. It affects health, housing, and the environment. As Maria Isabel said in her presentation, beyond the PQA community, which is currently fighting to be relocated far away from these plants and from the railway, there are hundreds of other small communities that suffer human rights violations due to mining. These are indigenous communities, these are riverside communities, these are countryside communities, urban communities, former slave communities, all who have reached the Amazon and their way of life is being threatened. Iron and steel that is produced in Piquiá continues along this railway and affects all of these different communities until it is exported out of Brazil. After it's received, Vale continues operating in Carajás. This has led to an expansion of the steel industry. This is carried out without any diagnosis of environmental impacts. There are no studies of damage and violations that occur. And there are no reparations plans that are ever drafted in this process. So all of these communities suffer these inhuman abuses that run all the way from lack of food to lack of information. Our monitoring at our NGO shows that women in all of these communities spend a lot more time taking care of their family's health than women who don't live in these affected communities. I could spend hours here listening to you all of the human rights violations resulting from company operations in the Carajás region. These violations are felt in a place where companies operate heavily. These steel companies have heavy operations. Your second question, Maria Isabel, were the gaps. There's a lack of transparency from public agencies and government agencies, licensing, especially mining companies. They criminalize community leaders. They don't follow Convention 169. There's a lack of oversight of these companies. There are no audits, human rights audits in these companies. Other gaps include the lack of laws that don't hold these companies responsible when it comes to due diligence, which is exactly what we're writing up today in this report. So just to conclude, this report will give more voice to the organizations and to the leaders in these communities who are fighting for the end of this corporate impunity. And all of these companies that are part of the steel industry from the beginning to the end that go through Piquiá de Baixo should be held responsible for what they leave behind in these communities. They pollute, there's deforestation, violations. And because of this, all of these communities need to resist. Thank you so much. And I'm more than happy to answer any questions if you have.
Thank you, Larissa. Thank you so much for this insightful intervention and for bringing the voices of the communities that you have supported closely for many years in the Amazon. I want to now turn to Marcel Gomez. Marcel is Executive Secretary of Reporter Brazil and has carried out the research of the report we launched today. And so really, Marcel, I want to take this opportunity for you to tell us more what you found out of this complex supply chain of the iron, how it travels from Brazil to the international markets, and who are the companies involved, what are their responsibilities with respect to the impacts that Larissa just described.
Maria Isabel, obrigado pelo convite. É prazer estar aqui.
Maria Isabel, thank you so much for the invitation to be here. It's an honor to be here. I'm going to talk a little bit about our report. And I'm so grateful that Larissa presented a little bit of those impacts, both environmental and social, that occur in the region. We think this kind of report on the supply chain, where we map out the actors, we watch out the stakeholders, this can really help other organizations, governments, and even the companies, so that they can take action to improve the conditions in the communities and the environmental conditions. Many times, people that consume the products and the companies don't really understand this supply chain and where they come from. So it's good to improve the transparency of the whole process so that people have more information about it. The supply chain related to Carajás with regard to iron and steel is a very long supply chain. It starts in the southeastern region of Pará, and then it crosses the entire state of Pará, as well as another state, which is the state of Maranhão. And from there, it goes to several countries in the world, both with regard to iron, pig iron, and steel. Those are the three main components that are in that supply chain. There's been a very big increase in the last years, especially since 2019. And what we see is a very big increase from China. And they consume a lot of pig iron. And this reduced the use that the United States had, and also Europe. And it's very interesting to see from 2019 to 2020, Asia as a whole tripled its consumption of pig iron, rather the purchase of pig iron from Brazil, especially from that Carajás region. In terms of iron ore, we also see Asia as the biggest buyer. In 2020, it bought nearly 58% of the net operating revenue. We see Korea, we see Taiwan, Japan. If we include those, it included 78%. Europe is about 4%. And the United States and Canada for 3.2%. And those are the products that are in that northern part, in the Carajás region by the company Vale. So 2021, in the 9 first months, that's what we studied. And there were 523 shipments, specifically for iron ore, because that's the product that gets exported from Carajás. There was a change in the last couple of years in both steel and pig iron in Brazil, where it's been more exported to the southern part of Brazil, especially the states of Minas Gerais and Espírito Santo. But the northern part of Brazil has focused on exporting iron ore. That doesn't mean the steel mills don't export a lot of the other two products, They do, but there's just been a reduction in the amount that they've been exporting. So from those 523 registered shipments that left that port, Ponta da Madeira, which belongs to Vale, from January and September 2021, 310 went directly to China. In the case of China, the two largest companies that maintain commercial relations with Vale are Bawao and Bao Steel, and they are the largest steel producer on the planet. There's another one, which is HBIS, and this is a well-known commercial partner of Brazil's largest mining company, which is Vale. In addition to China, there's Malaysia. Vale has its own port there, and there are 35 registers for shipments in that area. Those two destinations, China and Malaysia, represent 2/3 of the 523 cargo ships that were loaded with iron ore in Carajás. Shipments went to other parts of the world. We see 178 shipments of raw material. For Europe, there were 76. The biggest purchasers are ArcelorMittal, and that was the Germany, France, Spain, and Italy received those products. In Holland, we have 4 shipments. And we see in Italy, there were 3 shipments that were sent to the city of Toronto. Now, when you look at the corporate disclosure channels, it's possible to get an idea of how the steel produced from iron ore in Brazil is spread across multiple uses and production chains, from infrastructure structures, such as transportation, logistics, and energy, to automotive, food industries, technological, and packaging for food and beverages. Going back to Asia, in addition to China and Malaysia, other Asian countries such as Japan, we saw 16 shipments, through JFE Steel, and Nippon Steel got 7 shipments. And in South Korea, there were 11 shipments that were made there to POSCO. It's important to mention that these Asian companies receive the iron ore, they transform them into steel and steel products, and then those products are exported again to the consumer markets. And then they arrive in Western Europe, specifically for civil construction and the automobile industry. Larissa spoke very well to these points. She talked about human rights and environmental abuses in hundreds of communities here in Brazil. We want to talk specifically about Piquiá de Baixo and other regions in the Carajás mining project. These abuse include impacts on the land rights of local indigenous communities, children's rights, labor rights, the right to life, the right to housing, standard of living. And if the companies aren't directly responsible for abuses, they certainly put their reputation on the line, and they are able to help. They could help reduce such problems. For example, by identifying, mapping, and disclosing their direct and indirect suppliers of steel and iron, as well as their business partners. If we look all the way down to the raw material, we could understand how they are directly linked to the human rights impacts occurring in that Carajás corridor. And what we hope is that these companies use their influence to ensure that companies that cause or contribute to the abuses, such as Vale, can provide effective remedy to rights holders in the face of human rights abuses. And again, Vale is the main company in this whole system of exporting iron ore. Just to conclude, as I said before, even if these companies aren't directly involved, they are indirectly involved with these problems, and they can be held accountable for them, including legally. There are new laws in terms of supply chain in many countries. In France, for example, Germany, Holland, the United States has laws as well to protect their borders. And so companies who operate in those companies have to follow local laws with regard to the environment and human rights, even if their operations are in other countries. So with that, I will conclude my comments, and I'm here for any question that you might have. Thank you so much.
Thank you very much, Marcel, for this very comprehensive overview of what the report documents, and for perfectly connecting us to the second half of our discussion, where we will precisely explore what are the opportunities for accountability and remedy that a diversity of mechanisms, both at the OECD and the EU level, offer us today. Just before I jump to that, to remind you that if you have not yet had the chance to look at our report, in the chat you have the links to it, so go ahead and take a look at it. So let's now move on to the second section of the webinar, where we will debate how the context we will be able to address, or what are the new opportunities to address these human and environmental impacts that are connected in global supply chains. And for that, first we have invited Germán Samara, policy analyst and focal point for Latin America and the Caribbean at the OECD Center for Responsible Business Conduct, to tell us more about the relationship of Brazil and the OECD, and particularly with respect to responsible business conduct issues. From the perspective of the OECD and the guidelines for multinational enterprises, I would like to ask you, Germán, what are Brazil's compromises and how is the country currently performing with regard to social and environmental issues? In that respect, what is the role of the OECD? How can due diligence responsibilities help address the impacts that are in the higher tiers of the supply chains?
Muito obrigado, Maria Isabel, e bom dia a todas as pessoas que nos acompanham no Brasil.
Thank you so much. Good morning to everyone. It's in Brazil. So I'm speaking Portuguese, but I'm going to change to English.
For having me, and allow me first to congratulate FIDH and Justicia en Australia for this new report. I think this is very timely, both for the regional and the global discussions around due diligence. And for me, it's a pleasure to be in this panel and share with such experienced colleagues. I would like to begin introducing really shortly like the historical and legal background around Brazil's commitments before the OECD, and in particular before these instruments related to responsible business conduct. As you know, the OECD guidelines for multinational enterprises embed this expectation that businesses carry out due diligence to identify, to prevent, mitigate all those real and potential adverse impacts, but also to account for how those impacts are addressed. Today, we have 50 countries, of which 38 are OECD members and 12 are additional economies, including Brazil, and all of them have adhered to the guidelines and committed to this implementation. So it's important to remark that are not only those OECD members, but also all these other countries, such Brazil, that has committed to the implementation. And in fact, in the case of Brazil, despite not being a member of the OECD, the country is a key partner, in particular in the RBC agenda since 1997, with the addition to the guidelines, and subsequently by establishing a national contact point in 2000, which is located in the Ministry of Economy. And since then, the country has made different commitments to put these recommendations of the guidelines into practice. And this includes, and it's very important to mention, that Brazil has adhered to all the OECD Council recommendations on sectoral due diligence guidance. As you know, we have different sectoral guidance, for instance, for the agri sector, for the financial sector, for the government sector. And in this case, Brazil adhered specifically to the guidance for responsible supply chains on minerals on 2012, and the guidance for meaningful stakeholder engagement in the extractive sector in 2016. However, as we know, Brazil's ranking in global indexes reflect that its performance on a range of economic, social, and environmental indicators still can be improved, including by better including RBC considerations into public policies. And also, we are all aware that civil society is particularly demanding that both the public and the private sector take effective measures and actions to prevent and mitigate business-related impacts, and especially on those sectors, those economic sectors with higher probability of generating adverse impacts, such as the extractive one. And as this new report of FIDH and Justicia and Strilos shows, the extractive sector, and particularly the steel industry, needs to address a lot different specific risks and salient issues that are unfortunately really common, such on the rights on local and indigenous communities, impacts on vulnerable groups, such as children, women, and particular environmental and labor associated risks. This case of the state of Maranhão could be really any case across Latin America when we refer to negative impacts across the extractive sector. And Marisa just explained really well these direct and collateral impacts generated in these situations, and all the rights are involved, right? And this is why we're working both with governments, but also with the private sector to raise awareness about the importance of advancing due diligence and advancing on these commitments to meet the global expectations. And we realize that a lot of training and advice is particularly needed, especially from the private sector and in such important economic sectors. For instance, in last year, we ran a business survey in Latin America, and we collected data from more than 150 respondents companies operating in Brazil. And this survey showed that less than a half of the respondents, that is 40%, reported that they adopt an enhanced due diligence process when risks are identified. But we're talking that less than a half of companies are really like conducting due diligence in practice. And in addition, as part of the supply chain due diligence process, we found that just 37% of the respondents carry out a risk assessment beyond Tier 1. So notably, the majority of the businesses that participated, and all of these businesses that indicate having operations in Brazil, indicate the need for support and training on RBC-related issues. And we had more than 57 participants, 57 companies in Brazil reported the need for capacity building on due diligence. So to address this challenge, we are first, of course, calling the government and the state responsibility, as also Larissa mentioned before, as part of the commitment to enhance policy coherence and to require and support companies, particularly those operating in these high risk sectors such as mining, to embed social and environmental consideration to their risk management framework. And also, of course, we're conducting and trying to help businesses through capacity building to advance at the sectoral level. And the objective is not only to learn and exchange good practices, but also to take care and responsibility of their own supply chains, and to work in parallel with the whole industry, both at the regional, at the local regional, but also at the global level.
Thank you, Herman. This actually talks a lot about what due diligence means and the complexity of it. And I wonder, what is the OECD doing to strengthen the implementation of due diligence and promote policy coherence in Brazil, as well as within across government and government initiatives around due diligence?
Sure. Well, the first thing we should make clear is that the responsibility of conducting due diligence processes rely first on the companies, but then they are in turn responsible for their supply chain. And secondly, we should consider as I mentioned just a second before, the industry as a whole, and therefore we need collaborative and a collaborative approach across the industry, which is key to advance due diligence, especially in the weakest parts of the supply chains. I found really interesting what Marcel commented on how, for instance, some Asian countries are buyers, but at the same time, they are producers of goods that are sold to countries in the European Union, for instance. So this is why we need to work in the weakest parts of the supply chain, and of course, try to focus on those countries that are enhancing the standards and expectations. We have now government-backed benchmarks that reflect this global consensus on what responsible business conduct and due diligence actually looks like. And we can say after a decade of the UNGPs, the United Nations Guiding Principles on Business and Human Rights, and the latest update of the OECD Guidelines, these instruments are really fully aligned and mutually supportive. And furthermore, given this global trend towards mainstreaming due diligence across mineral supply chain, we believe that businesses are likely to find their clients and market partners increasingly requesting that they conduct due diligence in turn. And also, as Marcel already mentioned, more and more governments, and particularly in Europe, are passing these legislations on due diligence, and also including on mineral supply chains. And they are requiring companies to source minerals in responsible ways and to disclose how they conduct due diligence, as we mentioned, both on their operations, but also across their supply chain. So we need to think about the impacts in the entire supply chain. And this is important because most and many of these severe human rights and environmental harms are linked to companies that are in the end buyers in the European Union, for instance. So we need to address, as we said, through the whole supply chain and to check for the responsibilities there. And there is as well, as you all know, a growing consensus in Europe that voluntary is not enough. And that is why RBC should be built based on the resilience of the economy and looking for a fairer and more equitable globalization. And they realize the importance of this European Union Directive on Corporate Sustainability Due Diligence, which draft was just released yesterday by the EU Commission, and perhaps Sylvia will expand and explain better in this. But in parallel of these different legislations, as we mentioned before, Brazil has already different commitments before the international instruments, before the OECD. So we are calling basically the government and the companies, both not only companies operating in Brazil, but also those companies that are making businesses with Brazil, to advance on knowing and showing that they are not causing or contributing or linked to adverse impacts in the countries. And also this is a market demand that is reflected, for example, in the negotiations of the European Union and the Mercosur trade agreement, particularly in the chapter on sustainable development. So in simple words, we need to find where the minerals these countries are buying or refining, what is the context, where they come from, and then if the mining, transport, or trade of these minerals are linked to conflict or human rights abuses. So in this case, we need to establish red flags, which is basically like to enhance the processes of due diligence because of these salient issues and more risks that the sector involved. And in parallel, of course, we're calling companies to identify choke points in the supply chain, to collect more information, especially those companies that are buyers or also from investors. They need to collect this information. This can be done through individual efforts, but also as an effort of the whole industry to leverage and to encourage improvement on due diligence. And I would like to finalize by informing that we will launch in April an RBC policy review of Brazil. This is an exercise that the OECD developed for more than a year, comprising different analysis of the country's legislation, policies, and practices in different areas that are covered by the OECD guidelines. So different stakeholders impacting Brazil contributed to this review during the consultation phase, but also with specific comments and suggestions. And I would like to mention a couple of them. The policy review advocates for a coherent, clear, transparent, and inclusive process. So all the stakeholders can be part of policy making. And in particular, there could be an opportunity to work in the National Action Plan on Responsible Business Conduct, which is conducted by the Minister of Economy, and also the National Action Plan on Business and Human Rights, which is conducted by the Minister of Family and Women Rights. And then to protect specific rights, like the land of indigenous peoples, self-descendant, and other communities. Basically, those recommendations are in the report, and of course, we are looking forward to this launch. And thank you so much again.
Thank you very much, Herman. We ourselves also look forward to this publication on the 18th of March, if I understand well. We have been part of the organization, including Justicia Nos Trilhos and Connect Us, who have participated to contributing and feeding this policy review, and look forward to reading the final report. And as you were saying, Herman, it is important to frame these discussions in the wider context of responsibilities and the way in which states have regulated or should have been regulating the activities of companies. And there we point to the legislations that have been adopted in a number of countries, but particularly because yesterday the European Commission issued these proposals on Sustainable Corporate Due Diligence Directive that establishes some requirement for companies to conduct human rights and environmental due diligence processes. We wanted to invite Sylvia to comment on this proposal and to look at how the experiences of Piquia de Baixo and other communities affected by the Carajás Corridor inform the EU legislatures about what are the requirements that such law should meet in order to effectively address human rights and environmental impacts and provide both countries and companies with tools to address these negative impacts. So I'm going to give the floor to you, Sylvia.
Thank you very much, Maria Isabel, and obrigada pela invitación. My Portuguese is also not great, so I'm going to continue in English as well. Well, the case of Piquia de Baixo is clearly an evidence of why the future due diligence directive should not be limited to enshrining a corporate duty of due diligence, but should also establish consequences for non-compliant companies and ensure access to judicial remedies for these victims when the business failed to take action to identify, prevent, and mitigate human rights abuses and environmental harms across their global value chains. Currently, it is very difficult for affected communities, as it has been for the case of the community in Piquia, to hold accountable the companies at the top of the global value chains for their involvement in human and environmental harms. In this sense, the current proposal of the directive published yesterday makes an important step forward in the current legal landscape, since it includes the whole value chain in the scope of the proposal. However, there are some caveats to this. It is extremely important to note that the proposal covers both direct and indirect businesses relationships, and as it is often in the lower tiers where the most severe impacts occur, as Herman also mentioned, this is already a very good step forward. However, the proposal published yesterday also provides that due diligence measures will have to target subsidiaries, direct partners, and indirect partners, but only establish relationships in that value chain. This means established relationships have to be lasting relationships, and the concept of lasting is not very clearly defined in the directive, which opens a critical loophole and creates perverse incentives for companies that then would try to reduce the duration of their contract or establish relationships with suppliers and leave the relationship before addressing the impact. In terms of scope, although it's very limited to a very large companies and large companies in high-risk sectors, there is a constructive aspect in the inclusion of non-European companies in the scope of the directive. This would mean that, for instance, large non-EU companies participating in the single market, such as Tata Steel, would have to comply with the obligations in the European directive. This means that if, after mapping and assessing their value chain, they identify a linkage to the impacts in the Carajás Corridor, Tata Steel would be obliged by the European directive to take action on these findings to prevent and mitigate potential impacts, and to use its leverage to ensure that companies causing the impacts address this or effectively remedy the actual impacts. Moreover, in terms of the enforcement, the proposal includes a parent company and value chain liability regime, a crucial element for the directive to advance corporate accountability. Under the new law, companies could be held liable for harms committed at home or abroad by the subsidiaries, contractors, and suppliers, unlike in the French law, which is limited to subsidiaries and established suppliers and subcontractors, or in the German law, which excludes civil liability as an additional provision to the existing civil tort law in the domestic framework. The civil liability provisions in the directive give the opportunity to affected people to file lawsuits before courts, but there are many obstacles for this that are not addressed in the proposal, and I will speak about that further on. Furthermore, strong provisions on public enforcement via national supervisory authorities are an important complement to the judicial enforcement provided by civil liability in the directive. The EU proposal empowers member states' authorities and stipulates the creation of an European network of supervisory authorities to monitor the compliance with the law and impose sanctions based on turnover. However, it does not establish an amount, and it does not exclude the companies from public procurement, which is a big incentive for compliance. In this case, for instance, European buyers of the Carajás iron or steel, we could say ArcelorMittal, would be obliged by law to require a standard of care from its suppliers and to take all reasonable measures to ensure that severe risks are prevented, mitigated, and remedied. If they would fail to do so, the European counterpart would face sanctions from an administrative authority empowered to verify the compliance with the law. This is an improvement from the French duty of vigilance. However, there is lack of transparency, lack of access to information, and the contractual cascading provisions that may render these enforcement measures totally inefficient. We can see that in the case of ArcelorMittal, they have already published a vigilance plan in their branch in France in 2018. According to the legislation of the duty of vigilance, they should have been publishing a plan every year since then. We have seen then that the plan has not been efficiently enforced, and that it has not been updated, the information that is made available for communities or civil society to monitor this implementation of the plan. The fact that there would be supervisory authorities allowed or entitled to do so within the new legislation, it's already and therefore a step forward. However, for every high, there is a low in the proposal as well. And three key loopholes of the current draft are the scope not covering many companies, the legal hurdles in access to justice, such as disproportionate burden of proof, statute of limitations, high costs, and limited access to evidence, as I just mentioned, in terms of transparency, for instance. And the introduction of contract clauses as means of verification of compliance. This is a very dangerous aspect that still requires a further analysis, but that implies that in theory, the lead companies would be able to shift the responsibility down in the value chain rather than be obliged to themselves fulfill the due diligence obligations. In terms of the scope, by covering only large companies, the proposal falls very short from international standards set out by the UN and the OECD, for instance. This, for instance, targets all business regardless of the size and cover all sectors as well. In the case of the directive, only high-risk sectors and large companies in those high-risk sectors would be covered by the directive. The sector-specific approach is a major concern in that case, as both companies in sectors that are not considered high risk, for example, energy, transport, construction sectors, and companies with less than 250 employees in most risky sectors could have significant risk and impacts that are not currently required to comply with the due diligence obligations. The proposed regulation also ignores serious barriers to justice for victims. A recent study by ECCJ found that claimants have won only in 2 cases of all civil liability proceedings brought in European courts. And both cases were against Royal Dutch Shell. No final judgment has been ordered, and an EU transnational company has not been able to held accountable in terms of compensation for damages outside of Europe. Civil liability requires a strict causal link between the harm and the failure to conduct due diligence, which is often very hard to prove in court. Therefore, a presumption of such a link in certain given cases would be a reasonable and helpful solution to overcome this obstacle. To address the major hurdles for access to justice, the EU must provide reasonable time limits to file a lawsuit, a fair distribution of the burden of proof, the possibility of collective redress, and allow for representative action by civil society and trade unions, as recommended by the EU Fundamental Rights Agency as well. Finally, in terms of the due diligence obligations, the text of the proposal opens the door to a very dangerous loophole that risks making the law inefficient and preventing harm beyond the first year of the supply chain, and preventing victims from holding companies accountable. It implies that companies could fulfill their obligations by adding certain clauses. This is the contractual cascading that I mentioned. And these clauses in their contracts with their suppliers, they would be delegating the verification processes, and they would have the possibility of evade liability by establishing a third-party verification of the process. This is also has an implication in the effectiveness of the civil liability regime, given that the defense foreseen in case of harm caused by indirect partners risks making the law inefficient in preventing harm beyond the first year, and would prevent also victims down the chain from holding companies liable. Companies should not be allowed to shift the responsibility down their suppliers to get away with the harm by participating in industry schemes either. And the case of Piquia de Baixo illustrates this very well, and informs the reasons why the European legislation should address a very effective enforced mechanism for strict due diligence obligations.
Thank you so much, Sylvia. And indeed, the compliance-based approach used in the proposal would encourage to or allow companies in the value chain to avoid responsibility and pass it down the chain where the weakest links are already. And this idea of exclusively relying on codes of conduct or contracts between companies, third-party audits or verification is dangerous. And for many years, these mechanisms have shown that these are ineffective, have been ineffective, at least in the case of Piquia, to identify and address those impacts. So to transform the situation on the ground, we definitely need to go out of the business as usual. And we hope that the discussions around the proposal really get to strengthen all these points that you have mentioned. So before closing, I want to turn to Julia Neiva, who is working as coordinator of defense and socio-environmental rights at Conectas. Julia will talk about the case of Piquia in the broader context. What is it not an exception? Julia, can you tell us about more of what are the negative changes that are occurring in Brazil, of policy and regulatory changes that further allow this type of impacts to persist with impunity? What are the elements and policies that are needed to close those gaps, and how can the international actors such as the OECD or the EU help encourage these reforms that go strengthen the policy framework further.
Obrigada, Maria Isabel.
Thank you, Maria Isabel. I will definitely answer those questions. I first want to thank you for inviting me to be here. I want to congratulate everyone on this wonderful, insightful report. Repórter Brasil, FIDH, and GNT. I'm going to talk about PICIA, and I want to contribute so that we can show even more the need to having strong instruments to bring companies accountable. We do have that possibility, but we're not quite where we want to be yet. We need to get even better in terms of the legislation that's out there. So the first thing that I wanted to talk about is that all of us here, FIDH, OECD Watch, Connectas, the International Movement of Human Rights, we're going to have a report in March that's coming out, and it's going to have a lot of analyses in terms of those loopholes and gaps of governance. They're very similar to PICIA, unfortunately. And these are reports that we wrote with this context that we were invited from Brazil. We talk about climate change, pollution and its degradation, indigenous communities, violence committed against people who defend environmental causes, and also labor rights. That report, which is coming out in March, is also going to have some case studies so that we can better understand the impact in Brazil. And we have a Hirman here from OECD, and we want to see Brazil overcome those gaps so that Brazil can become a member of OECD. So I'm going to talk a little bit about that context in Brazil. It's really important to remember that we are in a historic moment of an irresponsible government who does not deal with any urgent problems here in Brazil. Problems of the pandemic, of environmental change. The president does not show any respect for these problems and for the respect of democracy in Brazil. We can hear this through Larissa and Marcel, that the most vulnerable populations are the most affected, and this is no surprise, because we have a structure that has very asymmetrical power system. And who is at the bottom? It's the indigenous people, the Quilombo communities, riverside communities, women, children, and workers. And what we want to have is responsible due diligence on behalf of the companies. And we have to really fill in those loopholes in terms of governance. For example, we had milestones that have been eroded by the Brazilian government since 2019, and the situation has gotten even worse with President Bolsonaro. We can talk about how the pandemic was dealt with very irresponsibly, how workers' rights have been degraded with new laws, the weakening of the oversight, lessening of transparency, less financing for Brazilian institutions that protect workers and the environment and indigenous communities. The Ministry of Labor was canceled and then they brought it back. Environmental legislation has taken a big hit as well. FUNAI has also lost a lot of its funding. There have been awful natural disasters. And then the bad administration of this current government have made it even worse, like in Mariana and other places. We don't want to see those happen again. There have been record numbers of deforestation. And also in the number of mining processes. So we are at a state of frailty in our country, and we need to regulate this sector. There's also a lack of information and access to information, and there's a lot of exclusion with regard to civil society. People with no technical expertise are in leadership positions, or they're not doing what they should be doing to protect the environment and workers and other people. There are also other law proposals that are proposing mining in indigenous communities, for example, or degrading workers' rights. Now, Isabel had a second question for me. We do need to strengthen the instruments that we already have, the tools that we have, and those mechanisms and the policies, but we need to do something else as well. Maybe we need to think about hybrid instruments or tools. We have a dirty list, for example, to combat slave labor in Brazil. Maybe we think about due diligence legislation that talks about human rights. But we always need to remember that if we have laws on due diligence that's mandatory, we need to strengthen our monitoring authorities so that they are independent. And that's fundamental, that those agencies that are monitoring are independent. And we need the community that is affected to participate as well. Sylvia, for example, talked about the onus of proof. And it's very important that we treat that as well, in terms of who has to prove things. We might be able to bring these new instruments or tools that are important in Brazil. We do have some strong tools. Maybe we need some new laws and ensure accountability and reparation on behalf of the companies. They need to be held responsible for what happens in their supply chains. I know I don't have a lot of time and I have much more to say. I just want to say one more quick thing. We should think about tools that can negotiate and propose a complement to or addition to the tools between the state and between the federal government and the states where these violations are happening. In PQA, for example, they operate at the international level. Very quickly, I want to say one more thing. And that's about how international organizations can help. So we have this moment in terms of Brazil becoming a member of OECD. We need to talk about if we want to be part of that, what are the commitments that we can make? Herman brought up the analysis of those processes. We have been trying to align with those for the last decade, but we need to strengthen those gaps, those loopholes, all the ways in which we protect people's rights in Brazil. And because of the problems that we have now, we cannot become a member of OECD. And Brazil also has to follow its responsibilities with regard to human rights, both in practice and also in terms of our constitution. There was a report last year on climate change, and they talked specifically about the new legislation being proposed in Brazil. And that responsible business conduct that Herman talked about from OECD has very important recommendations. And there's many points that have been presented on that responsible business conduct. The United Nations has had a very important role as well in terms of those special reporters. There's a group from the High Commissary on Human Rights in terms of holding companies accountable in Brazil. There's also the Inter-American Commission and other groups that talk about corporate responsibility. and OEP as well. So it is a very complex context, as we've been hearing. There is a higher awareness globally speaking, and I think we can talk about how that impacts Brazil. But we need a legislation that takes into all of that context and that really talks about reparations for the victims and the communities who are affected. And thank you. I'm sorry that I went over time.
Julia, and before we close, after such eloquent panelists, I don't have so much to say. Just to thank you very much for your contributions to this discussion that will certainly continue farther on beyond this webinar. I'm really happy that this was an opportunity to look into these very complex supply chain where serious violations that were pointed out by Larissa are occurring, that the supply chain that really makes us question how do we regulate the global markets where there is an increasing importance of companies that come from Asia and also China, where there is little regulatory space. And so the opportunity of European countries and the European Union adopting new legislation as a door to address also those issues that are occurring beyond the borders of the European Union. As what Marcel has said, the iron not only goes to the European Union, but the products with this iron charged heavily with human rights violations go back into the European Union through other channels. And that leads us to point out the need to improve the mechanisms and the approaches to human rights due diligence. And Herman pointed out the need for increasing transparency in the supply chain, the importance of red flags and identifying choke points also in those supply chains, as well as the key role of stakeholder engagement. Furthermore, the movement towards mandatory human rights due diligence in Europe is key and is an opportunity. The case of Piquia, the lacks or the failures of companies such as ArcelorMittal or Tata Steel to address this impact show the need that this proposal does not allow companies to shift their responsibility farther down the supply chain, that really provides elements that help address the barriers on access to justice and protect the rights of people, as with the many suggestions that Sylvia in very detail pointed out. And finally, that this legislation would definitely have an impact beyond the borders of European countries, prompting movements for the adoption of similar legislation, as Julia was pointing out, for example, in Brazil, and the need to ensure that those legislation also allow for increased redress of the harms that are already occurring and preventing and addressing the responsibility of companies that are linked to those violation. In that context, the OECD and the accession process that will open very soon with Brazil is an opportunity for a powerful economic organization to make sure that the bar of their standards is respected, and for sure that the countries that are members of the OECD that already have legislation in place will demand that Brazil keeps up its legislation and corporate practices to the level of the standards of the OECD. This should be an opportunity to improve the situation on the ground and make sure that human rights defenders, indigenous peoples that are currently under pressure find ways for corporate accountability. So thank you very much to you, to all the participants, to all the panelists. I'm sure the discussion will continue. And thank you very much to all the team of FIDH. I want to particularly say thank you to Ana Perez, without whom this report wouldn't have been possible, and this webinar neither. And to the interpreters that have allowed us to hold this panel in 2 languages. Thank you so much and hope to see you soon again.